I welcome all of you to the third session of the Energy Law course. In today's session, we will look into the theories on energy law. Let us quickly recap what we have covered in the previous session. In the previous session, we have traced the evolution of energy law through its various phases such as safety, security, economics, infrastructure development, energy justice, and so on. We also saw that these phases are interlinked with the energy life cycle. For instance, safety with extraction, security with production, economics with operation and supply, infrastructure development with consumption, energy justice with waste management, and so on. We also saw the scope for having more phases in the development of energy law in the years to come. In today's session, let us examine various theories on energy law. The theories are the energy trilemma, the theory of change in energy law, the power of energy law, the targeted legislation. While thinking about energy law, there are three considerations. At first, what energy law should aspire to? Second, how to fill the gaps between academics and professionals in energy law. And thirdly, the significance of interdisciplinary approaches. We know that energy law should go beyond regulating the exploitation of energy resources. In the face of climate change, technological disruptions, and geopolitical shifts, energy law must aspire to support decarbonization and sustainability, ensure energy justice and equity, promote resilience and security, and to enable innovation. Theories on energy law serve as tools that help us understand the purpose and limit of energy law, critically examining the existing legal framework, and design new forward-looking laws and regulations. Theories does not just describe the laws. It shapes what energy future is legally desirable. Engaging with theory enables better policy making, more inclusive legal framework, and a deeper sense of purpose in energy law's evolution. And with respect to the second consideration, how to fill the gaps between academics and professionals in energy law. We know that there is often a disconnect between theoretical legal scholarship and practical applications. For filling this gap, we need practice-informed energy research and policy experimentations. With respect to interdisciplinary approaches, we know that energy law cannot function in isolation. It intersects with other disciplines of law such as environmental law, for instance, climate change and biodiversity, corporate law, for instance, ESG, green bonds, and energy markets, with technology law, for instance, artificial intelligence, smart grids, and cyber security. With international law, for instance, international treaties, international organizations, and cross-border energy infrastructure development and so on. It also intersects with social sciences, for instance, public acceptance, behavioral change, and equity, and so on. Interdisciplinary approaches help understand the real-world impact of the legal frameworks, design more flexible and adaptive laws that work across sectors, and foster systems thinking necessary to tackle energy transactions and so on. Energy law is no longer just about regulating utilities. It is about shaping the future. To evolve effectively, energy law must embrace interdisciplinarity, stay grounded in social realities, engage with practitioners and scholars alike, and above all, serve the broader goals of justice, sustainability, and resilience. Let us examine the first theory, which is the energy law and policy triangle. Energy law and policy is in the center of the triangle, and on the 3 points of the triangle are economics, politics, and environment. These 3 issues each are trying to pull energy law and policy in their direction. According to this theory, effective and efficient energy law and policy will balance these 3 aims to deliver the best outcome to the society. This theory is also referred to as the energy trilemma. For examining or explaining the energy trilemma, the researchers should use this as a lens to see their own issues that they are researching. For instance, if a change happens in environmental law policy, that can have some impacts in economics and politics. Therefore, it is necessary to examine how a change in environmental law and policy will be impacting economics and politics. One can probably compare this with Newton's third law of motion, which says that for every action there is an opposite reaction. Therefore, while studying a particular aspect, it is necessary that we should also examine the negative impacts that are caused. In the context of the energy trilemma, we can probably observe that in the history, the energy law and policy was dominated by economics. And this had actually created a lot of problems from the point of view of energy security in the states where energy law and policy were dominated by researchers in economics. Therefore, for the purpose of delivering an effective energy law and policy, it's necessary that we should see the impacts that are there in economics, environment, and politics, not just the positive impacts but also the negative impacts. Let us examine the second theory, the theory of change in energy law. According to this theory, Energy law is subject to change from three levels of law: international, national and local, and what happens at one level will have an impact on another level. In developing, analyzing and in decision making on energy law, it is necessary to think about why it changes and what are the elements of change at international, national and local levels, and how do these different levels relate it. In essence, this is also similar to Isaac Newton's third law of motion, which states that for every action there is an equal but opposite reaction. But in the case of energy law, it is not necessary that a change at one level of energy law will be resulting in an opposite reaction which will be negative. The reaction could be complementary or it could be in accordance with the change. Let us see the international change in energy law. The international change in energy law can be through international treaties, international agencies, international politics or relations, and international business and trade. Let us see international treaties. International treaties are the first drivers of change in energy law internationally, because these treaties will result in individual states making changes in their own national laws. There are so many international treaties. Probably we could also see treaties in the context of international environmental law that are regulating energy activities. For instance, the UN Framework Convention on Climate Change, Kyoto Protocol to the UN Framework Convention on Climate Change, the Aarhus Convention, and so on. International agencies, the best example is that of International Atomic Energy Agency. International Atomic Energy Agency regulates the nuclear activities in different states who are members to IAEA. Whenever IAEA comes up with new regulations, then all member states are supposed to make changes in their national laws following the regulations made by the International Atomic Energy Agency. Another example is that of the International Association of Oil and Gas Producers. Another driver of international change in energy law is international politics or relations. It's very common that different states have highly developed political relationship with other states for energy infrastructure development. Usually this happens through the exchange of highly advanced technology and so on. This year, India and France have signed the letter of intent for advanced modular reactors and small modular reactors. India also has agreements with UAE, Russia and France for energy infrastructure development. Another major driver in international change in energy law is international business and trade. India is a global exporter of wind turbine blades, having facilities in Tamil Nadu and Gujarat, exports globally and also exports solar PV modules. In the year 2024, the total exports of solar PV modules amounted to $2 billion. This shows that how international business and trade could result in international change in energy law. Let us examine the national change in energy law. There are majorly 4 drivers that are to some extent related with the international change in energy law, and they are the aim of the government, the availability of finance, advances in technology, and societal preferences. Let us take the first driver, the aim of the government. Depending on which government is in power, there can be a change in energy law in that particular country. Say for example, with the election of Angela Merkel's government in Germany in 2005, there was a change in energy law in Germany. Availability of finance is an important consideration since the economic crisis in 2007. Every state wanted to attract investment for the purpose of energy infrastructure development, but at the same time faces the risk of investors claiming guaranteed returns on their investments. We can see legislations passed in different jurisdictions for promoting investments in the energy sector for the purpose of energy infrastructure development. We can recall India's Electricity Act of 2003 and the Renewable Energy Act of 2003. Advances in technology are also very significant. We can see the changes in national law just because of the aspiration for countries to use the advanced technologies in the context of wind energy and solar energy. The good examples are that of Germany and Denmark. Another example is that of carbon capture and storage technology. And another important driver is that of social preferences. Because of the social systems prevailing in different jurisdictions, there can be different social preferences. Say for example, the Republic of Ireland has consistently shown an anti-nuclear stand. For a nuclear law to be passed in Ireland, there would be a referendum which would allow everybody to vote for it. In the absence of that, it is impossible to have a legislation on nuclear law in Ireland. But if you see the experience from the United Kingdom, the United Kingdom population see nuclear energy as part of UK's energy mix and an option to reduce the CO2 emissions. Let us examine the local or individual change in energy law. There are 3 entertaining perspectives that an individual can have at certain time when thinking of a particular energy issue. A world perspective, a national perspective, and a local perspective, which capture the complexity of thinking about energy law at a local level. Let us examine the world perspective. This is actually based on a cosmopolitan philosophy where individuals see themselves as world citizens and they see any prospective change in energy law is for the betterment of society. This actually happens through international treaties or is led by international organizations. The national view that is actually dependent on how individuals are selecting their representatives to form the government by voting for them, and the government so elected in return coming up with an energy law and policy. This view is actually led by the national governments. And the third view, the local view, where individuals are forming their own opinions about a particular energy law and policy, depending on how that particular policy is impacting that individual. This is also related to NIMBYism, which means not in my backyard. We have seen resistance across the jurisdictions regarding the establishment of an energy law project at a particular place. People might see this particular project as good, but at the same time, they do not want that to happen in their resident premises and so on. This actually shows the complexity of local or individual change in energy law. The third theory is that of the power of energy law, the theory of targeted legislation. Energy policy is the driver of the legislation in many respects. In order to have an effective energy policy, it is necessary to have a legislation to deliver it. This is particularly very important to secure investment from private sector for the development of energy infrastructure. And again, it is important from the point of view of initiatives that a government may see as being instrumental in delivering the energy policy it has promoted. A very good illustration is from Denmark. The policies in Denmark that actually allow individuals to take part in energy decision making, and the policy also provides public-private ownership in energy assets, and the net result is that the energy services are available at a lower price for the consumers. Therefore, energy legislations have the power to ensure that energy law developments are happening sustainably, taking into account the concerns of everyone in society. Let us summarize what we have discussed. Energy law can be a powerful source of remodeling for the energy sector, and energy law can also ensure that there is increased investment in the energy sector for energy infrastructure development as well as for research and development in energy law. All energy law scholars are required to move the discipline forward and consider the theoretical development of energy law rather than to bring theory from other areas of laws to focus on specific problems. In order to finalize the emergence of energy law as its own subdiscipline of law, energy law needs its own theory to evolve and grow. This actually highlights the significance of theories in energy law for the development of energy law. Let's see what's coming up. In the upcoming session, we'll explore the main sources of international energy law, including treaties, customary international law, general principles of law, international court decisions, and soft law instruments. We will examine how these sources interact to shape global energy governance and influence national energy policies. Thank you.